Good evening. This is John Milburn. I'm the course coordinator for Laws 11046, Law and the Environment. This week, the prescribed reading is Bates Chapters 6 and 14. We're dealing with environmental administration and management as the overall heading. So, in the context of environmental administration, environmental management, we need to talk primarily about executive and the courts, which both have a role to play in various ways in administration and management. There are four main headings that I want to discuss tonight. The first is the concept of merits reviews against judicial review. The second is the concept of standing in environmental litigation, which I must confess is chapter 17 of Bates, so I'm getting ahead of myself a little in that regard. The third issue that I want to talk about is criminal enforcement as a means of managing environmental issues. And fourth is the concept of costs, which increasingly is becoming a powerful tool in the arsenal of environmental managers and administrators. So firstly, let's talk about merits reviews and judicial review. You would have seen a reference to these concepts fairly consistently throughout the legislation, throughout the commentary. They're really quite simple in general terms. As many of you know, I'm a member of the Queensland Civil and Administrative Tribunal. So as the name implies, a lot of the work that we do, that I do, in hearing cases is administrative work. And it might sound boring, but trust me, it's really very interesting. And for the most part, the work that I do at QCAT relates to merits reviews. Judicial review is a different concept, and I'll just explain it briefly. Firstly, a judicial review, as the name implies, is a review done by a judicial officer, so usually a court. And at the state level, there is judicial review legislation. At the Commonwealth level, there is also judicial review legislation. Where a litigant takes action in relation to judicial review, that litigant is looking for the court to make a ruling in relation to not the decision that was made by the person whose decision is being challenged, but rather the way in which the decision was made. Was it lawfully arrived at? Were lawful procedures followed in coming to that decision? And of course, the threshold question there is, was the decision made by a person or a body with legitimate lawful power to make that decision? So when one is seeking an order pursuant to judicial review, you're really very much looking at who made the decision. Did they have power to make the decision? Did they follow the appropriate rules in making that decision for the court to decide? The court really isn't interested in what decision was made. It's, can that decision maker lawfully make a decision, and did that decision maker follow the appropriate rules and guidelines? That's what judicial review is all about. Now, a merits review, which is administrative law, which is what I do, what we do at QCAT and other jurisdictions, not just an administrative tribunal. It's a merits review is a reconsideration of the decision. Now, the Planning and Environment Court will deal with its litigation primarily as merits review litigation. So what that means is that the judge in a Planning and Environment Court decision in Queensland, as will a member of QCAT, decide the question afresh. And the concept is to make the decision which is the better and the best and preferable decision in relation to a particular matter. So what is the correct and preferable decision is the requirement for a decision maker in a merits review. So where you have a merits review, we're not, in the context of Planning and Environment Court, we're not really looking at whether the council followed the right guidelines, whether they did or didn't consider appropriate or relevant evidence. That may be consequently of interest to the court, but really what the court is doing is making the decision for the decision-making body. So the executive, the administrators who make decisions, in a sense, always have the court looking over their shoulder, because at any time the matter could be taken out of their hands, placed into a court which steps into the shoes, as it were, of the decision maker and makes what is intended to be the correct and preferable decision. So there we have it. That's, in a nutshell, the difference between judicial review and merits review. Let's move on to the second issue, which is the concept of standing in environmental litigation. So if a litigant in a P&E matter is not happy with a decision that was made in relation to, was not happy with the decision that was made in relation to an issue, then that person is able to take the matter to the Planning and Environment Court, but only in certain circumstances. So the concept of standing requires that person to show not only that they have a good cause of action, but here's the key: they have to show that they have some relevance in the proceedings, that they have some right to be there. We call it standing to sue or locus standi. Give an example. If I saw something being done, let's say at a local school where I was unhappy with the way in which, say, a teacher was disciplining a student. Now, if I went to court and sought an order effectively seeking to punish that teacher or to have the court make a decision about whether that teacher did the right thing or not, the first question, in simple terms, would be from the court, what right have you got to come here and ask that question? Now, I'm not trying to be rude about it, but I'm just saying, you have to have an interest in it. Or let's say you saw some people down the block building a fence, and the neighbour who built the fence came to you and said, "Oh, look, my neighbour on the other side hasn't paid for his or her share." I mean, as a good Samaritan, I might say, well, let me go and sort this out in court. I go into court arguing that somebody else should pay for a fence down the road. Again, the court would say, look, that might be a legitimate argument. It might be that the person who is affected by the non-payment has a good cause of action, but you don't. You live 3 blocks down. I mean, really, what right have you got to come in here and sue someone? You have no interest in this proceeding other than being a neighbour. So the best thing you can do is encourage a neighbour to bring action, but you can't bring action. So that's why we talk about the relevance. So when it comes to considering environmental decisions or planning decisions that have been made, the first question has to be, does this particular person or does this body have a right to be there? Do they have sufficient right to have the matter heard by a court or a tribunal? Now, generally speaking, this concept of standing or locus standi is conferred upon a person who is aggrieved. So if you're affected by what's happening, then you have the right to argue, you've got your foot in the door to say, I have a legitimate interest in this and therefore I want to be a litigant. Now, what does that mean in real terms? In New South Wales, in the context of environmental law, they've made it really simple, and I think this is the way that all the jurisdictions will go in the future. Parliament has effectively said, when it comes to dealing with environmental issues, everyone has standing. Everyone is affected by this, so you don't have to show any special standing. You will have locus standi as a matter of course. So when I talked about maybe a busybody neighbour wanting to take somebody on, that really doesn't apply in New South Wales litigation. In other jurisdictions, it does apply. There are 2 ways that you can get your foot in the door. You can say, I've got standing, I've got this right to be in court through common law, or I have this right to be in court through legislation. Now, think back, common law is judge-made law, as opposed to statutes, which is law made by parliaments. So at common law, the people who have the right to pursue litigation are those people who I suppose, have a special interest in the context of environmental law, have a special interest over and above the interest of the general population. So it's not like in New South Wales where everyone can say, I've got an interest, therefore I'm entitled to sue. In environmental litigation in Queensland, let's say, at common law, you need to show that you've got a special interest over and above the general population. Now, that might be because you're affected adversely economically, or it might be that you're affected because of special social or cultural or political or other environmental interests. So you've got to show some interest at common law. So there's case law in relation to Indigenous groups pursuing matters against mining companies on the basis that they have special social or cultural interest over and above that of the general population. Other than that, the interest might be statutory based. In Bates, there's reference to the decision of the North Queensland Conservation Council against the Executive Director, Queensland Parks and Wildlife Service. It's a 2000 decision. In that case, Justice Chesterman adopted an approach which effectively broadened the parameters by allowing generally contestants to challenge what was described as arguably unlawful developments, and that was an extension on the statutory law. So in general terms, where it comes to having standing, it's easier to show standing pursuant to statute than it is to show it at common law. At a Commonwealth level, which is going to be relevant for many of environmental issues, you should also consider the Environment Protection and Biodiversity Conservation Act. Now, that extends the test to allow for a person who's aggrieved at an administrative judicial review level to organisations that in the last 2 years have been engaged in a series of activities to protect or conserve or research the environment. That's section 487. So that's another thing that you can look at. If all else fails and you can't show that you have a special interest, you might be able to lobby the Attorney General to join the proceedings, and the attorney has a right to join at any stage, or you might be able to create a class interest or class action. That might be relevant as well. So a whole group of people, or it might be that you can enforce environmental laws some other way, perhaps through injunctions or administrative remedies for prosecution. In other words, encouraging people that do have the right administratively to take up certain actions. All right, so have a read in relation to that concept of standing. And the point of what I'm trying to say is that if you're not happy with a decision which is made in the context of environmental administration and management, then you need to be aware that you have to show some ability to get your foot in the door, as I've described it, in court, and that's what we call this concept of standing. Okay, the third topic I wanted to speak about tonight was criminal enforcement. Now, this, of course, is a very important and valuable tool for environmental administrators and managers. And criminal prosecution, it is reactive, but it's very powerful. It's reactive in the sense that you can't bring prosecution on the basis that someone might commit a crime. You have essentially wait for the crime to be committed and then pursue the matter after that. There might be special legislation that applies. So the Environmental Protection Act of 1994 creates an indictable offence where the maximum penalty is imprisonment for 2 years or more. And we see that in a few pieces of legislation. I'm just going to stop there and explain briefly what I mean by an indictable offence. In simple terms, offences are categorised in different ways depending on how serious the offence is. And generally speaking, an indictable offence is the more serious of the offences. And I'm going to make it really simple by saying that we have indictable offences or we have summary offences. Now, it's a little bit more complicated than that, but for the purposes of this course, I'm going to leave it at that: indictable versus summary. Indictable means it's capable of being the subject of an indictment. And an indictment is a document which is presented in the higher courts. So, for example, in the District Court or the Supreme Court, then the proceedings commence by presentation of a piece of paper which is called an indictment. So it's as simple as that in many ways. If this is an offence where the law says an indictment can be presented, then we call it indictable. Summary offences are matters that are dealt with by a magistrate in a court of summary jurisdiction. So summary matters are dealt with by magistrates. Indictable matters, which are the subject of a presentation of an indictment, are dealt with by judges in the District or Supreme Court in a criminal context. Now, I hate to say it does get a bit more complicated than that, because perhaps primarily as a cost-saving factor, the governments have progressively been forcing indictable matters to be dealt with summarily so that they're dealt with more quickly and easily. So offences which are indictable offences, meaning that in general terms they're capable of being the subject of the presentation of indictment, are dealt with at the lower level summarily, because that's what Parliament wants us to do. So I'm sorry it gets a bit confusing, but I hope that that's made at least some sense of what we mean by indictment versus summary. And the more serious your indictment, the less serious a summary. Now, when it comes to criminal prosecution, bear in mind, of course, that unlike civil litigation, in the criminal sphere, the prosecutor needs to establish every element of the offence and do so beyond reasonable doubt. If they can't show beyond reasonable doubt that every element of the offence has been made out, then the person will be found not guilty. Bear in mind also that when it comes to criminal prosecution, or the lead up to criminal prosecutions, individuals have the right to claim privilege against self-incrimination. What that means is that if someone is the subject of potential criminal law proceedings, they have every right to say to the prosecuting authority that they don't wish to answer any questions. That right continues even if they're in the witness box in court. And that's not just a defendant in a criminal law proceedings, it's any witness in the criminal law sphere. So always people have the right to say, I refuse to answer that question on the basis that it might incriminate me. Here I go again. You really do want just a straightforward answer, and I keep saying, oh, but there are exceptions. In Queensland, there is one exception that I can think of, and that is in the Crime and Corruption Commission. There are certain hearings which which compel people to answer a question, even if it's against interest. But beyond that, that's a very limited exception. All right. So general rule is that in criminal proceedings, you have the right to say, I don't wish to answer that question. I don't wish to incriminate myself. That right doesn't apply to companies, and the Caltex case from 1993 is authority for that decision. Now, there are a whole range of different categories of offences, apart from indictable versus summary. Some offences are created through what we call strict liability. If the thing happened, then you are going to be criminally liable. If there's a huge oil spill over the barrier reef, you're going to be liable. There would perhaps be no defences to that. Others require a mental element of intent. Now, that intent means that you actually willfully intended something to happen, but can also include actions which are reckless in the extreme or even negligent. So if, for example, I was charged, I was driving along and I hit a pedestrian and caused them grievous bodily harm, I might say to the court, well, I didn't mean to hit that person and injure them, but if it came out in evidence that I had been looking down and watching a movie on my laptop, which was on the passenger side, and not even watching the road, sure, I didn't mean to hit someone, but I was reckless to the point where my actions carry with it criminal responsibility. So that's still, there's still that mental element. Now, you'll come across some reading which deals with vicarious liability. Vicarious liability means that you are liable for the actions of others. And that might be the case in environmental law in the context of management. So management may find themselves liable vicariously because of the actions of employees. Now, as you might expect in criminal enforcement, there are some defences. One of them might be an honest and reasonable mistake of fact. It might be due diligence. So there are the usual defences can apply. Now, just a quick word on sentencing. If someone is found guilty or does enter a plea of guilty, then the sentence need not be necessarily jail. And even if it is jail, there are a whole range of different options that we call jail sentences. For example, a person might be sentenced to actual time in jail to serve the whole time. Or they might be sentenced to jail, but it might be suspended after a period of time, in which case they're released and they just have to stay out of trouble for that period, which is nominated by the courts. Or it might be suspended immediately, or that person may be released on parole at a certain date in the future, or that person might be released on parole immediately, or that person may become eligible to apply for parole at some stage in the future, which is different to being released on parole on a certain date. Or it might be community service or a fine. So the whole range of different sentencing options. And generally speaking, an early plea of guilty will carry with it a lesser penalty than one where the person takes the matter to trial. Another thing is a conviction being recorded or not is an important factor in that regard. In the Commonwealth jurisdiction, where there's a Commonwealth offence, it's very, very difficult to avoid a recording of a conviction, much easier in the state regime. And sometimes, if you're acting for a party who's subject to prosecution, having no conviction recorded is a more important outcome than the actual penalty itself. So keep that in mind. Okay, fourth and final thing for tonight, I just wanted to talk about costs. In the reading, you would have read about costs, legal costs, and there's a few little tricks to this. The first is that more and more the way in which people deal with objectors or prosecuting authorities deal with issues to do with non-compliance is to effectively penalise people through the costs regime. So the cost can be huge in litigation matters. So $100,000, $200,000, $500,000 to get yourself into proper and full-on litigation is not necessarily out of the question. So if someone comes to you and they're contemplating taking on some environmental litigation, you need to talk to them about this concept of costs and perhaps the risk that if they lose, they may be ordered to pay some or all of the costs of the other side. And as we said, that can be huge. So in those circumstances, the loser may have to bear all the costs they've borne themselves, and in addition to that, they have to bear a substantial part of the costs or all the costs of the other side. Now, that's not always going to be the case. The court may make no order as to costs, meaning each party pays their own costs. But if the court does make an order for costs, it'll be of one of two types. The first is, and this is probably the most common, the court may order what we call party and party costs. And effectively, that means that the person who wins is not entitled to claim everything that it actually cost, but only those things which are allowed at law, and that can be limited. You know, it's a bit like going to see the doctor and paying a certain amount and not the full amount because that's being covered through Medicare. So that's a little bit like the party and party. There's, you know, you get some but not all. Solicitor and own client costs, or indemnity costs as we sometimes call it, that's different. That's where you're ordered to pay everything that it costs the other side, as between them and their solicitor, their lawyers. So that's the issue of costs. Okay, thank you very much. Are there any questions? No? Okay. Well, I hope that you're all doing well with your work. Thanks very much to those of you who've already submitted your assignment. I'm sure that others are working on it busily tonight. And I hope that you're not having too much grief in relation to that matter of Fraser Coast and Byrne. That's the one that's certainly caught the attention of most people. And the purpose of that exercise, amongst other things, is really to give you some insight as to what it's really like. The intention is in that one is not to spoon feed you. You have to find the material. You then have to make an assessment of what's important in that material, and you need to then glean from that material what is worthy of comment and what you don't comment about. So it's very much open-ended, and it's intended to be like that. You know, there's no point doing a university course and not being at least ready and having some idea of what it's like in real practice. So the purpose of that case is to say, well, here's where we're at now. Tell me what's important out of this lot and give me some idea of where you think this is going. So that's the intention of that exercise. All right, so if there's no questions, we'll sign off for tonight. Thank you very much for listening, and all the best. Please share information through UCrew. Look forward to seeing you next week. Bye.